So, namaskar all of you. So, our OJS 2023-24 prelims test series test number 1 जोटा constitution ऊपर थिला तो तार first part ता first 25 questions सेटा आज हम डिस्कस करिवा एटा आपण जो ऐप रे आपको एक्सेस करि परिबे क्वेश्चंस और द डिटेल्ड सॉल्यूशंस करिका तो each test रे 100 टा क्वेश्चंस रहउची हमें ताको डिस्कशन क्लास को चारिटा parts रे डिवाइड करिबा 25 questions each रे. Okay, so which of the following is an extensive original jurisdiction given by Constitution of India to the Supreme Court? Okay, extensive original jurisdiction given by Constitution of India to Supreme Court, right? So जदि एटी exclusive original jurisdiction देता था, exclusive माने केवल Supreme Court पाखरे रहबा सके. Okay, it is extensive reach, right? So देखो तो options भितर enforcement of fundamental rights, advising the chief executive in legal matters, hearing revenue cases of appeal, किंबा hearing criminal cases of appeal. So correct answer आपनकर रहउची कोन? Enforcement of fundamental rights. एटा आपनकर answer रहउची. Okay, so तारो detailed solution टा देखंतु. Enforcement of fundamental rights. Okay. So article 32 of the constitution re sethare apanakara okay extensive original jurisdiction of Supreme Court sethare diya ichi ki directly jane tara fundamental rights jodi violate hoji tale se Supreme Court ko jai paribo. Okay,
excuse me sir, sir sorry to interrupt in between sir, extensive or exclusive bit it sir, mu confuse ho jati difference ati koi pariye.
Exclusive mane only with that particular authority a context रे ता माने कोन ना परंतु exclusive हला कि सेही राइट ता केवल सुप्रीम कोर्ट पाखरे ही अछि. लेट्स से हमें कहबा इंटर स्टेट डिस्प्यूट्स ओडिसा ओके आउ लेट्स से छत्तीसगढ़ कि आंध्र भितरे लैंड डिस्प्यूट हला
सर
लैंड डिस्प्यूट हला तो एटा कोठी हमें ओडिशा हाई कोर्ट रे तो कर परिबानी सेमती आंध्र हाई कोर्ट रे भी करि होबा एटा केवल सुप्रीम कोर्ट को आपण जे परिबे.
ओके
कुछ बोले तो एटा हला एक्सक्लूसिव. एक्सटेंसिव माने एक्सटेंड रु एक्सटेंसिव.
ओके
ठीक अछि ता माने जोटा एक्सटेंड कराइछि अधिका तार ओरिजिनल रु आउरी अधिका ओके डोमेन को आपण एक्सटेंड करचंदी एक्सटेंसिव ओरिजिनल जुरिस्डिक्शन से एक्सटेंसिव टा सही हिसाब से कहला इट एक्सटेंड्स ओके किंबा जो सुप्रीम कोर्ट रो पावर रो डोमेन टा को एक्सटेंड करे.
ओके
कुछ बोल एक्सक्लूसिव माने कोन?
यस सर, यस थैंक यू सर.
ओके तापरे यू कम टू द सेकंड क्वेश्चन. एटा थोरे डिटेल से ऐप रे देखि देबे से तारो जोडा हमें कॉन्स्टिट्यूशन क्लासेस से कंप्लीट करतु से तारो कांसेप्ट सुरा भी देछ. Who determines the number of judges in the Supreme Court? The Supreme Court itself, the Parliament of India, through laws made from time to time, Prime Minister or the Council of Ministers. Okay, so this we know that आपणकर strength judges करा केते रहिबो सेटा आपणकर Parliament determine करे. Okay, so B would be the answer. Okay, so that would be the Parliament which would decide the strength of the judges. Okay, so tara Parliament of India through laws made from time to time. So the Parliament, if it wants, it can increase the number of judges depending on various things which they have to consider. Okay, like pendency and other issues also. Okay, so eta hella apanangara Parliament of India through laws made from time to time. Okay, for example eti apan dekhantu explanation re the Supreme Court number of judges act which has been amended several times to increase the number of judges in the Supreme Court is an example of Parliament exercising its authority in this regard. Okay, so this is Parliament of India through laws made from time to time. third question ko asantu, if a chief minister dies, then what would happen? The senior most member of council of ministers automatically becomes the chief minister. The council of ministers automatically stands dissolved. The chief justice of the high court succeeds him or her as chief minister. The governor immediately appoints a new chief minister. Okay, so ଯେତେବେଳେ chief minister को death होची ताले तांकर जो council of minister टा सेटा automatically dissolve ହେଇଯିବ ठीक अछि तो पुणी नुआ chief minister के हेबे ओके आउ थोड़ी election हबनी but that council of minister will be dissolved maybe exactly same लोग same ministers मानको आउ थोड़े same portfolios दिया ହେଇଯିବ with some other chief minister but that particular council of ministers which was associated with that chief minister who died that council of ministers automatically stands dissolved okay so come to the explanation of question 3 so all the ministers in the state are appointed by prime minister according to his or her preference okay eta ministers parliamentary okay सेटा हैला प्राइम मिनिस्टर का प्रेरोगेटिव स्टेट रे हैला चीफ मिनिस्टर ठीक अछि नॉट प्राइम मिनिस्टर चीफ मिनिस्टर स्टेट रे okay right he or she gives advice to governor for their appointment so as he/she dies the council of ministers is dissolved and a new council of ministers is formed by the new head of the state government जोटा कि आपनकर जे नुआ chief minister हेबे okay now come to question number 4 The Supreme Court of India is different from its counterpart in the US. Supreme Court of India or Supreme Court of US. Okay. Ta bhitare major difference kon. Okay. What is the major difference between the powers and the role of the Supreme Court of India and United States? The first is in its role as guardian of the Constitution, in its advisory role, guardian of the Constitution, to seti bhi seta constitutional guardian. Okay. In its advisory role. So this is where the difference will be there. Okay. In its advisory role. In its role as supreme authority in judicial field of the country, seta bhi dita same. In its writ jurisdiction. So answer would be in its advisory role. Okay. So both good differences achi, kichi similarities achi. Okay. The Constitution of India grants the Supreme Court an advisory function under Article 143. Okay, जोटा कि प्रेसिडेंशियल रेफरेंस कथा हमें कहूछु कि प्रेसिडेंट ऑफ इंडिया जदि तांको किछि ओपिनियन दरकार सुप्रीम कोर्ट रो से रिक्वेस्ट करिवे सुप्रीम कोर्ट को गोटे प्रेसिडेंशियल रेफरेंस देकी कि एई विषय रे आपण किछि कोंते कोन करिवा कथा ठीक अछि सो only when they are asked supreme court will give its advice okay so ई जिनसटा आपणकर यूनाइटेड स्टेट्स ऑफ अमेरिका रो सुप्रीम कोर्ट रे नहीं ओके सो इट कैन नॉट इश्यू एडवाइजरी ओपिनियंस ओके और इट कैन नॉट बी कंसल्टेड by the president or even by their parliament congress okay so that is the main difference between Supreme Court of India and Supreme Court of US fourth question now come to the fifth question In which of the case has the Supreme Court assured the citizens of compensation for loss of injury caused by any public authority? Okay, assured the citizens of compensation for loss or injury caused by any public authority. So, this is basically the common cause versus Union of India. Okay, say case re apanakara okay so in this landmark case Supreme Court has laid down that the citizens are entitled to compensation for loss or injury caused by acts of public authorities ठीक अछि so suppose गोटे ड्रेन कराउछ ओके तो से जो कॉन्ट्रैक्टर को गवर्नमेंट देइथिला ड्रेन टा करिया पैसे कोन करछि त राती रे खोली देकी पड़िछि ताको आउ as per the standard operating procedure कि जो rules ताको सेटा ता ऊपर ताको किछि रखिबार थिला जेमति कि लोकता भीतर न पहुंचे ओके आ से दिन राती रे वर्षा हे गला सकाळे आपण साइकिल नै कि बाइक नेकी जाउछन्ती ता भितर पसि गले ठीक अछि कैन यू क्लेम compensation so yes you can claim compensation काहे कि ना this is an act of negligence ताकू कवर करिवार थिला बट से करिनी ठीक अछि तो सो कॉमन कॉज वर्सेस यूनियन ऑफ इंडिया ए जो एक्सप्लेनेशन उडा टिके डिटेल्स से पढी देबे तर कोन हो ना सेही क्वेश्चन न होई पारे बट रिलेटेड क्वेश्चंस आपनकर आसी जाई पारे ओके जोडा कि एक्सप्लेनेशन रे डिटेल्स से देछि who is appointed as an ad hoc judge of supreme court okay so ad hoc judge of the supreme court who appoint हुआ पे कौन qualifications ताका दरकार a sitting judge of high court duly qualified for appointment as a supreme court judge a person fully qualified for appointment as a judge of the supreme court a retired judge of supreme court or an acting judge of supreme court so basically it is a sitting judge of high court duly qualified for appointment as supreme court judge okay setala that is the answer for question number 6 तार explanation आउ जदि आपण articles उडा देखिबे okay 127 that deals with the appointment of okay supreme court judge so article 127 रे आपण सेटा पाइबे sitting judge of high court duly qualified for appointment as supreme court judge article 127 of the constitution of india allows for appointment of sitting judge in high court as an ad hoc judge of the supreme court okay केतेबेले एटा हबो where there is a necessity and the judge appointed must meet the qualifications required for supreme court judge okay so the article 127 now come to question number 7 right to privacy is protected as an intrinsic part of right to property and personal liberty which of the following in the constitution of india correctly and appropriately implies the above statement okay so Article 14 and the provisions under 42nd Amendment to the Constitution. Article 17 and directive principles of state policy in Part 4. Article 21 and freedoms guaranteed in Part 3. And Article 24 and provisions under the 44th Amendment Act to the Constitution. So, obviously, right to life or personal liberty कहले हमें सीधा जान लो Article 21. तो बाकी आउ किछ हमु देखिया दरकार नहीं गोटिए ही एथि okay option रे Article 21 देछि so that will be the answer that is C will be the answer. Okay, now go to the detailed answer. So, right to privacy is protected as an intrinsic part of right to life and personal liberty under the Constitution of India. The protection is implicitly found within Article 21. Okay, then case laws jodi hame dekhiba landmark case ta obviously that is justice case Uttuswamy versus India Union of India. Okay. So here the Supreme Court, it recognized the right to privacy as fundamental rights protected under Article 21. Okay. Tapare, come to the next question. Question 8. Which one of the following statement is correct? Rights are claims of state against its citizens. Okay, claims of state against its citizens. Right. So that is obviously wrong. Rights are privileges which are incorporated in constitution of a state. Privileges. Okay. Rights are claims of the citizens against the state. This is the thing. Jurisprudence पढ़िचंती अलगा भी पढ़िचंती कि आपण निजरो किछिटा फ्रीडम बंधा पकोचंती स्टेट पाखरे ओके आउ गोटे क्विड प्रो क्वो हिसाब रे आपण जानचंती कि स्टेट आपनको आपनको किछिटा फ्रीडम नै कि आपनको आउरी किछिटा फैसिलिटीज दब so rights are claims of citizens against the state okay for example hame taxation आउ तार हिस्ट्री और का देखतरु very basic question is why should I pay tax ठीक है so I am paying tax in exchange okay I am expecting something from the government ठीक है good roads है वाला other things I will respect your laws which you have made ठीक है जोड़ा हमें you know the sovereign concept जोड़ा हमें पढ़िथिलु ठीक है so rights are claims of the citizens against the state C is the answer okay now So ei part ta dekhantu, rights serve as mechanism through which the citizens can claim certain freedoms or entitlements that are protected and upheld by the states. These rights limit the power of the state over individuals and ensure that the government operates within confines of law and morality, aiming to protect individual freedoms and promote social justice. Okay, so that is question number 8. Now come to question number 9. Which is not a power of the High Court? Which of the following is not a power of the High Court? Supervision of all courts under its jurisdiction, that is one of the powers. Jurisdiction over revenue matters. Supervision over tribunals constituted by law related to armed forces. Eita High Court ko power under re rueni. Okay, जोटा कि armed forces tribunals varika seta अलग. Issue writs for enforcing fundamental rights or other purpose. 226 under re, that is there. So B, A, B out D tanka rights achi, but C ta tanka right nahi. Okay, so come to the discussion of question 9. Okay, so eta ko under re asuchi, to eta A, B out D. Okay, that you just go through. Eta ko under re asuchi, Armed Forces Tribunals are established under a separate act of Parliament, the Armed Forces Tribunals Act 2007. Okay, so High Courts generally do not have direct supervisory control over Armed Forces Tribunals. Okay, so but जो last line ta देखिए, that is also important. एमती ना कि Armed Forces Tribunal जदि किसी गोटे order देला सेटा को आपण civilian court को नहीं परिबेनी, ठीक है? ताको जदि आपण कहउछन मो fundamental rights ओके violate हेची, अवश्य जो माने Armed Forces थांती ताको fundamental rights से ठीक curtailed थाए. Okay, that is there even under part C of the Constitution. ठीक है? But you can take it जदि basic fundamental rights आपण violate हेची ताले आपण ताको okay Armed Forces Tribunal order को challenge करि परिबे High Court रे, Supreme Court रे. So that is question number 10. Normally High Court does not have jurisdiction over that. Okay, supervision over tribunals constituted by law related to armed forces. Question 10 ko asantu, which one among the following statement regarding the constitutionality regarding the constitutionally guaranteed right to education in India is correct? Okay, this right covers both child and adult literacy and therefore universally guarantees education to all citizens of India. Eta bhul, eta khali kon apanakara primary education ko apan dokchen 6 ru 14 barsh pilangu. This right is a child right covering the age of 6 to 14 and becomes operational from the year 2015. Okay, so kichita thik achi ki ista bhul achi. This right has been taken from British Constitution, which was first welfare state in the world. Okay, this right has been given to all Indian children between 6 to 14 under the 86th Constitutional Amendment Act. Okay, so out of this D is only correct. ठीक है? 86 Constitutional Amendment Act सेटा गोटे देइतला उपरे कोन 2015 लेखतिला सेतरे. Okay, so first हम देखिबे सेटा incorrect, एटा incorrect काहेकि ना एक होची कोन ना एटा पूरा adult education भी cover करूची. Okay, that is not there in right to education. Okay, so operational eta hela 2015 रे नुहा. Okay, तापरे आ गोटे हला the right to education was brought from England. Okay, so but it is a homegrown act. Eta amara okay nijara hi ame ko right to education ta ama constitution re eta aguru thila koti thila. Directive principle of state policies, okay, article 45 re eta thila aguru originally. So initially the constitutional assembly debates hela सेतबेले this was discussed, but we did not have the resources at that time. एते पैसा नथला हम पाखरे कि फ्री और कंपलसरी हमें प्राइमरी एजुकेशन अफोर्ड करि परिबा. तनो सेटा रखा हला कि परे जेतेबेले आपन पाखरे पैसा आस जिवो सेतेबेले आपन ताको ओके बनेबे. Okay, fundamental right. तो गोटे टाइम रे तले we were you know powerful enough, okay, economically आमे आर्टिकल 45 जोड़ा ओरिजिनल कॉन्स्टिट्यूशन रो 45 थिला ताकू आर्टिकल 21A को आनदेल. ठीक अछि, सो कीप दैट इन माइंड. तापरे कम टू क्वेश्चन नंबर 11. With reference to Lok Adalats, which of the following statement is correct? Lok Adalats. Okay, Lok adalats have the jurisdiction to settle matters at pre-litigating stage and not those matters pending before any court. Okay, so pre-litigation तो obviously सेटा तो हुए माने कोर्ट को जोटा जिबा आगुरु. ओके आउ जो केसेस गुरा कोर्ट रे भी पेंडिंग अछि सेटा भी लोक अदालत थ्रू रे आपण ताको ओके आनी परिबे और ताको सॉल्व करि परिबे. ओके जो कांसेप्ट ऑफ एडीआर हमें कहू अल्टरनेट डिस्प्यूट रेजोल्यूशन. देन लोक अदालत कैन डील विथ मैटर व्हिच आर सिविल and not criminal in nature. Okay, so lok adalats generally okay are competent to deal both, but setere criminal offenses re compoundable criminal offenses heithiba darkar. Okay, compoundable heithiba darkar, right? Tapare every lok adalat consists of either serving or retired judicial officers only and not any other person, which is wrong. Setere advocates mane bhi thanti, social servants, social services jo mane achanti se mane bhi thanti. Okay, retired judicial officer किंबा serving judicial officer se generally taro chairperson हिसाब रे thanti. Okay, so now come, so that is D. None of the statement given above is correct. Okay, jeti statement dechi segra sabu bhul, right? So none of the statement above is correct. So out के details से अपन देखिबे. Purpose कौन? Lok adalats provide an alternative dispute resolution mechanism that seeks amicable settlements through conciliation and mediation, aiming to reduce the burden on courts. तापर finality दबा पाई. ठीक है तो ना cases उड़ा इनकी चाली थी वो सब बड़े. The award of Lok Adalat is considered final and binding on all parties. It has the status of decree of a civil court. Okay, तापर types बहुत प्रकार लोक अदालत अच्छी, national लोक अदालत, permanent लोक अदालत, okay, and other लोक अदालत specific जोड़ा particular purpose by. Okay. Now come to question 12. Which of the following statements about Indian judiciary is not correct? The Constitution of India has not provided for double system of courts as in United States. Okay, so it's not correct. Double system of courts माने ना सेठी कोन तांकर जेतु दीटा अलग अलग कॉन्स्टिट्यूशन थाए, गोटे फेडरल कॉन्स्टिट्यूशन थाए, गोटे स्टेट रो कॉन्स्टिट्यूशन थाए. तांकर कोर्ट्स उडा भी अलग, तांकर फेडरल कोर्ट्स थाए आउ स्टेट रो कोर्ट्स थाए. ठीक अछि, हमर एटी सिंगल कॉन्स्टिट्यूशन integrated judiciary. Okay, so which is not correct. So India has not provided for double system of courts as in United States. This is correct. We do not have a double system of courts. The organization of subordinate judiciary in India varies slightly from state to state. Okay, so that is also correct. Okay, tabare every state in India has separate high court. Okay, every state in India has separate high court. So this is incorrect. कहीं ना कितने गुड़े state रो joint high courts अच्छी. Every state in India जितने state अच्छी अपन करो सब गुरो. Okay, गुटे गुटे separate high court नहीं. Joint high courts भी अच्छी. Okay, तीनिटा joint high courts अच्छी हमारा. ठीक अच्छी. जोड़ा कि दीटा किंबा अधिका states रो. Okay, तांको पाकरे jurisdiction रही. तापरे D आसिला, the Supreme Court has issued direction to constitute an all India service to bring about uniformity in designation of officers in criminal and civil side. Okay, so that is also okay correct. Supreme Court has given such a direction. Now come to the explanation. Punjab Haryana High Court, okay, Guwahati High Court, out Bombay High Court. So एथरे कौन ना अपन one or more states. When the Punjab Haryana High Court, as the name suggests, Punjab और हरियाणा तो सेतरे रहउची ही. Okay, आउ चंडीगढ़ भी सेतरे रहउची. सेमती गुवाहाटी हाई कोर्ट पूरा नॉर्थ ईस्ट बेल्ट को देखुची, आसाम, नागालैंड, मिजोरम, अरुणाचल. आउ बॉम्बे हाई कोर्ट रे आपनकर ओके महाराष्ट्र आउ गोवाटा भी रहउची. ओके, तेनु all states do not have their separate high courts. ठीक अछि, तेनु कि टिके ट्रिकी तो नुह किंतु टिके आपन को माइंड एठी अप्लाई करिया पे पड़े. Now come to question 13. A British citizen staying in India cannot claim right to freedom of trade and profession equality before law, protection of life and personal liberty, freedom of religion. So freedom of trade and profession. A hela tar answer. Okay. कौन ପାଇଁ? Because बाकी laws गुड़ा सेगुड़ा समस्तଙ୍କ ପାଇଁ. Citizens हुअन्तु, aliens हुअन्तु. किंतु freedom of trade and profession जोटा कुआ गला, okay, सेटा केवल citizens को ପାଇଁ ही, okay, है. So you can see equality before law, Article 14, protection of life and personal liberty, Article 21, और freedom of religion, से सब fundamental rights उड़ा for all, that is citizens को ପାଇଁ भी plus aliens को ପାଇଁ भी. तेणु आपण जदि constitution रो bare act रे देखिबे दीटा terms यूज हेतिबो, गोटे थिबो citizens आउ गोटे थिबो persons. जो जगह रे पर्सन्स यूज हेची सेटा जानिबे समस्तଙ୍କ ପାଇଁ. ओके, जे इंडियन हो कि जे इंडियन न भी हो, तो एई तीनटा एटा पर्सन्स को ପାଇଁ समस्तଙ୍କ ପାଇଁ. But okay, the right to freedom of trade, occupation and profession एटा केवल citizens of India को available अछि. Okay, so come to question 14. In context of India, which one of following is correct relationship between rights and duties? Okay, specifically pacharchi in context of India. Rights are co-relative with duties. एमती नहीं कि अपन का rights और duties किसी so duties and rights go hand in hand. Rights are personal and hence independent of society and duties. So rights are independent. सेटा अपन को बेसी important. अपन rights सब enjoy करेंगे, duty किसी ना करें भी चलेगा. Rights, not duties, are important for advancement of personality of citizen. Duties, not rights, are important for stability of the state. Okay, so ethi Indian constitution re, okay, our rights or duties ho ja position achi, A is the correct answer. That is, rights are co-relative, okay, to duties, because they are interconnected, okay, and they provide a balance between the individual and society. Western societies re kon individual ro right ta basic important. Middle East आउ केते गुडे ट्रेडिशनल सोसाइटीज रे जदि आपण जिबे जोटा कि बेसिकली थियोक्रेसीज गुडा अछंती सेठी सोसाइटल वैल्यूज आर मोर इंपोर्टेंट देन इंडिविजुअल राइट्स. ठीक अछि. तेणु फॉर एग्जांपल सऊदी अरेबिया रे एमती बहुत गुडे लॉज थिला, एबे तो चेंज करलेनी, जेमति कि ड्राइविंग करिया पई वुमेन वर नॉट अलाउड. ठीक अछि, एबे हेलानी सेटा. आगु को जदि वुमेन माने बाहर पड़े जिबे दे वुड रिक्वायर ए मेल पर्सन टू गो विथ देम. ठीक अछि. तो से टाइप रो सब जिंस आपण कहि परिए, बिकॉज़ सेठी कांसेप्ट है कि सोशल वैल्यूज और सोसाइटी रो राइट्स, ओके, एज ए सोसाइटी सेटा बेसी इंपोर्टेंट देन इंडिविजुअल्स राइट. बट इंडिया हैज बैलेंस्ड बोथ. ठीक अछि. सो राइट्स एंड ड्यूटीज आर इंटरकनेक्टेड. ओके, बट जो डिटेल्स उडा दिया हिची, ओके, बहुत ही लंबा अछि, तो सेटा आपण ऐप रु थरे थरे पढिबे. काहे कि ना एई पर्टिकुलर क्वेश्चन नो एई जो डिटेल डिस्क्रिप्शन रु आपनकर अलगा क्वेश्चंस आसी जाय पर. ओके, तापरे आसंतो क्वेश्चन नंबर 15 की, जजेस ऑफ हाई कोर्ट्स कैन बी रिमूव्ड फ्रॉम ऑफिस बिफोर एक्सपायरी ऑफ दैट टर्म बाय द प्रेसिडेंट. ओके, सो at his discretion, माने प्रेसिडेंट को इच्छा हिसाब रे, on the recommendation of chief justice of high court, on recommendation of chief minister of state, on a request of parliament, on a resolution passed by 2/3 majorities of its members. Okay, so that is the answer. That is, if parliament passes a resolution by 2/3 majority. Okay. So, केमती था procedure टा कौन? It's an impeachment like process. We all know that impeachment term टा, it's a quasi judicial process. और केवल president को India, president of India पे लागू है. केमती loosely हमें कही दो चु impeachment of this and that, impeachment of chief justice of India, सेटा impeachment हुए नहीं. बाकी सबू केस रे removal होगा. ठीक है तो impeachment केवल president को पे ही हमें तक को use करो. ठीक है. Loosely we are using it for other constitutional posts also, but technically speaking, impeachment, which is a quasi judicial process, applicable only for your president. Okay, so it's an impeachment like process. ठीक है, and it is outlined in the Constitution and the Judges Inquiry Act. तापर security of tenure. The judges of High Court and Supreme Court, they enjoy security of tenure 60 to 65 years पर्यंत. Okay, then parliamentary process. So the removal process can be initiated by motion in either house, supported by specific grounds or proven misbehavior or incapacity. तापर special majority एथे दरकार. So at least 2/3 of the members present and voting, and a majority of the total membership of the house. Okay, total membership house हो जाए तारा half plus सेतिनो जो मैं जतिक जन अचंती सेठी तांको भितरु 2/3. Okay, then there will be a presidential order. जदि resolution टा pass होला parliament रे, then president can issue the order for removing the judge. Okay, so बाकी तीनटा ऑप्शन काहे की भूल सेटा भी आपण देखो देखि दे परिबे. Next, come to question number 16. The Attorney General is the first law officer of Government of India. In order to be appointed as Attorney General, a person must be qualified to be appointed as Judge of Sessions Court, High Court, Supreme Court, or District Court. Okay, Attorney General करो बहुत गुड़े अपन करो powers भी अच्छी कौन ना, it is a political appointment. कितने समय पर्यंत से appointed है कि रही परिबे तांकर tenure सेमती किछि नते. ठीक अछि, जदि गवर्नमेंट चाहेला ताको जति वर्ष पर्यंत गवर्नमेंट अच्छी रखि परिबो, 15 दिन रे भी बाहर कर परिबो, 2 वर्ष रे भी बाहर कर परिबो, से निजे भी रिजाइन कर दे परिबो. ठीक अछि. So the Attorney General आउ भी किछिटा ताको स्पेशल पावर्स दिया अछि, जेमति कि से पार्लियामेंट रे जाई कि बसी परिबे, डिबेट्स करी करे पार्टिसिपेट कर परिबे, वोट कर परिबे नि किंतु पार्टिसिपेट कर परिबे. Okay, so 16, that is Supreme Court. Supreme Court रो judge हबारो जहाबी okay qualification अछि एजिंग करो. Okay, Attorney General करो सेया थिबा दर, right, सेति की eligibility तांकर थिबा दर. Article 76 of the Constitution lays down the qualification for Attorney General of India. Okay, the person must have qualification necessary to be appointed as Judge of Supreme. The Supreme Court judge hapi kon darkar, citizen naithibe India ro, judge of one or more high courts for at least 5 years, or advocate for of high court for at least 10 years, or distinguished jurist in the opinion of the president. ठीक अछि, जे कि आपनकर advocate ही नथिबे but eminent jurist थिबे. Okay, so Attorney General कोन, he is the chief legal advisor to the government of India. Okay, next, family courts decide disputes relating to the subject matter of the family court, domestic violence, marriage affairs, property matters, or consumer affairs. Okay, so आ भितरु आपनकर family courts, marriage affairs generally आपण कहि परिबे. Okay, primarily it is basically related to marriage. Family Courts Act of 1984. Matrimonial disputes, child custody and maintenance, guardianship, succession and inheritance. Okay, so next question, question 18. The doctrine of prospective overruling, it an important question, was adopted by Supreme Court of India in case of which one of these? Champakam Dorairajan versus State of Madras, Golaknath, Keshwananda Bharati, or Kehar Singh. Okay, concept of or the doctrine of prospective overruling. Okay, first set up on prospective overruling. So suppose Supreme Court gote 5 वर्ष आगुरु गोटे a judgment देइथिले. Now situation has changed, societal expectation change हेछि, lot of other things have changed. एबे किंतु से भाबुचंती कि नै सेटा ताकू उल्टा जजमेंट ता दोतन कि से जजमेंट ताकू ओके सेटा जा भी कुआइछि ता ऑपोजिट की तरह अगेंस्ट रे कि अलगा डायमेंशन से आ गोटे जजमेंट दोचन. तो एबे जो नुवा जजमेंट दिया हैला दैट विल prospectively overrule that old judgment. Prospective और retrospective कौन कि जो आजिरु परंतु हमें frame of reference आजि का डेट नबा. ओके, जो बैक डेटेड हमें कहू ताको retrospective कोन, आजि परे जोटा इंप्लीमेंट हबो ताको prospective कोन. ता माने सुप्रीम कोर्ट जदी आजि गोटे डिसीजन देले आजि ठू सेटा ओके कार्यकारी हबो आगुरु गोटे दिया हितला सेम मैटर ऊपर ताकू से ओवररूल कला ठीक अछि दैट इज द कांसेप्ट ऑफ prospective overruling किंतु कथाटा हला को ओके केस रु एटा कराइछि okay from which case this concept of prospective overruling टा आछि so that is the गोलकनाथ case okay टिके टिके चारटा केस ऊपर आपण जानिबे okay so the landmark case was pivotal in establishing the doctrine of prospective overruling in India. Supreme Court ruled that Parliament could not amend the fundamental rights enshrined in Part 3 of the Constitution. Prospective overruling, so prospective overruling is basically, it means a court's decision applies only to future cases and does not affect the validity of past transactions or decision made in reliance on the previous law. Okay. Why did this doctrine emerge? The doctrine was introduced in Goloknath case to address the concern that overruling previous Supreme Court judgments could create legal chaos and uncertainty. Okay, so that is the concept of prospective overruling. Baki jo tinta bhi dechi, kaha kaha upare tara main focus kon thila se case so seta bhi janantu Champakam Dorai Rajan. Okay, communal reservation policies, Keshwananda Bharati basic structure. Okay, au K.R. Singh, that is detention. Okay, issues related to detention. Now come to question 19. Salaries of judges of Supreme Court are determined by Parliament, pay commission appointed by President, law commission or Council of Ministers. So seta hela Parliament. Okay, Parliament determines it. ताकू केते बळे बढ़ेबार अछि कम करियार अछि आ ए सब जिंस जो से बढ़ेबे कि salaries गरिका तो सेटा इजीली करा ही परिबो विदाउट using article 368 माने सिंपल मेजॉरिटी रे भी अपन एटा कर परिबे ओके आर्टिकल 368 रे कोन अपन जो अमेंडमेंट करूछथि कॉन्स्टिट्यूशन रो सेटा अपन इधर स्पेशल मेजॉरिटी रे करछथि किबा स्पेशल मेजॉरिटी विथ concurrence of okay ratification of half of the states सेतरे करछथि but there are very very ଆମେ କେମିତି କହିପାରିବା ବହୁତ ସିମ୍ପଲ ଜିନିଷ ଗୁଡା जोटा कि आपण आउटसाइड आर्टिकल 368 भी आपण अमेंड कर परिए कॉन्स्टिट्यूशन को दैट इज थ्रू ए सिंपल मेजॉरिटी तो ए जो सैलरी बढ़ा हो कौन सी कॉन्स्टिट्यूशनल पोस्ट रो ता भीतर जाउछि ओके सो पार्लियामेंट कैन डू इट आर्टिकल 125 ऑफ इंडियन कॉन्स्टिट्यूशन explicitly states that the salaries of Supreme Court judges are determined by Parliament. Parliament has authority to set, increase or decrease these salaries as it deem appropriate. Okay, तापर जदि पर्टिकुलर स्टैट्यूट को हमें देखिबा ताले Supreme Court judges salaries and conditions of service act 1958. Okay, तापर question 20. Under the writ of mandamus, the court can ask a person to be produced. Okay, एला गोटे गोटे देखि देबा ask a person to be produced for habeas corpus, right? Order to transfer the case from one court. Okay, तो सेटा आपनकर हे परिबो ओके सर्टेरियरी रे ठीक अछि ask to let a person free for a temporary period or direct the government to do or not do something. Okay, so mandamus ro concept for we command, that is the meaning of mandamus. Okay, so we command to seta d hoba apanagara. Okay, so let us go to the detailed discussion of this. So that is D. Okay, mandamus, direct the government to do or not do a thing. Mandamus re etik inso man rakhibe, writ of mandamus can be issued to a public authority only for doing obligatory work. Obligatory work माने तांकर जोटा तांको पोस्ट संगे रिलेटेड जोटा मैंडेटरी वर्क. तो डिस्क्रिशनरी काम थिबो सेठी जनरली मैंडामस टा इशू होएनी. ओके, डिस्क्रिशनरी माने तांको इच्छा हिसाब से करि पारंती न करि पारंती. Right, so that is the writ of mandamus. Then come to question 21. Which one of the following is not a qualification for a person to be appointed as district judge? Okay, not a qualification to be appointed as district judge. He should not already be in service of central or state government. Okay, so this is required. He should have been an advocate or a pleader for 7 years. This is also. he should have completed 30 years of age. Eta not that. It varies from state to state, but minimum, okay, 35 tha, should be recommended by High Court for appointment. ଯେମିତି କି ଆମର ଏଠି OSJS ର ପରୀକ୍ଷାଟା ହଉଛି, ଏଟା କଣ High Court କରୁଛନ୍ତି, High Court ତାପରେ recommend କରୁଛନ୍ତି appointment ପାଇଁ, OPSC କରୁନି ସେଇଟା, ବୁଝିପାରିଲେ? ତ ଆ ଭିତରୁ C is the correct answer. He should have completed 30 years of age. It is generally 35 years of age. Okay, so he should have completed 30 years of age. That is wrong. He should not already be in service of center or state government. That is correct. He should have been an advocate or pleader for 7 years. That is also correct. And he should be recommended for, okay, appointment for High Court judge. 22%. Which one among the following is not guaranteed by Constitution of India? Okay, what is guaranteed by Constitution of India? Only the fundamental rights are guaranteed. तामने पचाराला से या पचोची कि अभी तो fundamental rights कोटा नुआ. Okay, so freedom to move freely throughout the country. एटा Article 19 under रे अच्छी हमारे. Okay, एटा मन रखिए. Throughout the country, you have the freedom to move. Okay, free movement रो Article 19 रे अच्छी, bearing a few exceptions like inner line permit areas and other areas जोड़ा की public areas नो. आपण कबे मु न्यूक्लियर पावर प्लांट भीतर को जिबी, ठीक अछि, सेटा पॉसिबल नो. ओके, आउ जदि बाहर को जिबे, फॉरेन को जिबे, आपण पाखे रिसोर्सेस अछि, पासपोर्ट अछि, पैसा अछि, टिकट अछि, ताले आर्टिकल 21 रे आपण सेटा मेनका गांधी केस दे दिला, you can go abroad. Okay, so freedom to move freely throughout the country, that is guaranteed by your constitution. Freedom to assemble peacefully without arms. Okay, so it is very important, especially law students को पाई. तो कौन है ना, सिविल सर्विस रे भी हमें कॉन्स्टिट्यूशन पढुछु, सेठी हमें डायरेक्टली कॉन्स्टिट्यूशन रो लेट्स से हमें गोटे जनरलाइज्ड वर्जन टा पढी दउछु, सीधा भाषा रे हे जाउछु. बट एज स्टूडेंट्स ऑफ लॉ यू हैव टू concentrate on the bare act. Okay, तो एठी जो कहला फ्रीडम टू असेंबल पीसफुली विदाउट आर्म्स, एटा कोन पीसेबली लिखाई छै हमर एक्चुअली कॉन्स्टिट्यूशन रे. Okay, freedom to own, so that is there, obviously you can assemble peaceably without arms. Okay, सेटा अपन को दिया छि आर्टिकल 19 अंडर रे से फ्रीडम टा guarantee दउछि आपनकर कॉन्स्टिट्यूशन. Freedom to own, acquire and dispose property anywhere in the country, एटा आगु थिला आर्टिकल 19 रे भी थिला, आर्टिकल 30 रे भी थिला, बट सेगुडा एबे हो ओके नहीं, राइट. So that is the right to property. Okay, so this is the answer. This is not guaranteed by the constitution. It is still there in the constitution 300A, so it's a constitutional right to have property. Okay, but it is not a fundamental right, so it is not guaranteed by the constitution. Tapar dela freedom to practice any trade or profession, again article 19 re say freedom ta apan ko diya hichi. Okay, so you can see the right to property, initially it was there, okay, in part 3. However, 44th Constitutional Amendment Act, okay, removed it from its category, made it a legal right. Right. Then come to question 23. Which of the following is incorrect regarding Schedule 6 of our Constitution? एबे बहुत अपना news रे एटा देखुतिबे, many states, okay, or union territories are saying that हमको एथरे पसे दियंतु, right? So question 23. Which of the following is incorrect regarding Schedule 6 of our Constitution? The areas are administered as autonomous districts over which the executive authority of the states extends. Autonomous districts. Okay, incorrect Jota. So this is correct. The government has powers to create new autonomous districts. This is also correct. The autonomous districts are provided with elected bodies known as district councils. Correct. It deals with administration of tribal areas of Arunachal Pradesh, Manipur and Nagaland. Okay, so basically that is not Jatikita states देइछि एटा भूल देइछि. एटा कोन ना हमर tribal areas Assam, Meghalaya, Tripura, Mizoram. Okay, so D is incorrect. ठीक अछि, D टा हला आपनकर incorrect. So purpose of the 6th schedule, Assam, Meghalaya, Tripura, Mizoram, 8 states ro, okay, tribal areas who administer केमति करा, right? We can go through the other options and the description. Question 24 percent. Judicial reviews doctrine of partial annulment. Okay, so judicial review with but doctrine of partial annulment is related to which article of the Constitution? Okay, Article 13, 32, 141 and 246. Okay, आम डॉक्ट्रिन ऑफ एक्लिप्स एगुडा भी डॉक्ट्रिन से पढिथिलु. पार्शियल एनलमेंट माने कोन तमने बुझचंती ना जदी गोटे लॉटे अछि. ओके, आउ सेटा तार किछि पोर्शंस ओके आपनकर फंडामेंटल राइट्स अगेंस्ट जाउछ ताले सेही पोर्शन उडा आपण आ कार्यकारी हे परिबनी. पूरा लॉटा नुह जो पोर्शन उडा it is okay and it is in line with the fundamental rights ताले सेही पार्ट उडा आपनकर ओके कार्यकारी हे परिबो. That is the doctrine of partial annulment. So that comes from Article 13. Okay, laws which are inconsistent with fundamental rights are void, right? So that is Article 13. Okay, laws inconsistent with or in derogation of fundamental rights shall be void. It empowers courts to strike down parts or total laws, okay, which violate fundamental rights. So doctrine of severability, जोटा कि partial annulment हमें कहूँ. This doctrine is a principle used in judicial review. It means that if part of a law is found unconstitutional, the court may strike down only that specific part, leaving other portions of the law intact. किंतु तारो भी बहुत गुड़े एतरे जिंस हमको देखिया पड़िबो जेमति कि जो पार्टटा अनकॉन्स्टिट्यूशनल अछि कि स्ट्राइक डाउन करूची, इफ दैट इज द सोल ऑफ द स्टैट्यूट. ओके, जदि सेटा हला सोल ऑफ द एक्ट ताहले ताकू काटी देला पर एक्ट रो किछि रहिबनी, ताहले टोटल एक्ट को आपनको ओके फोबाडिया में पड़िबो खाली सेति. किंतु जदि जेति कि अनकॉन्स्टिट्यूशनल कोर्ट डिटरमाइन कले सेति कि पार्ट को काटी देले बाकी जो पार्टटा रहिला सेटा इंडिपेंडेंटली से स्टैट्यूट को होल्ड करके रखि परिबो ताहले सेमति करा जे परिबो. Okay, that is the thing. Now come to question 25. Who is authorized to transfer the judges of one high court to another high court? President, Chief Justice of India, Collegium of Judges of Supreme Court, or the Law Minister? Transfer of judges. Okay, so technically speaking, it is the President. President ko na rahi hoga seta. Okay, it is the President. Article 222 of the Indian Constitution expressly states that President of India can transfer a judge from one high court to another high court. This transfer is done after consulting with Chief Justice of India. Okay. So 25 questions hala. So we'll stop here. So every part re hame 25 questions ta discuss kariba. Okay. So जो मैंने टेस्ट दे सारी गोटे इंपोर्टेंट जिनस इन योर ऐप. ओके, यू गो थ्रू द टेस्ट. ओके, टेस्ट रो जो डिटेल सॉल्यूशन एटा जो आसीबो. ओके, द बेस्ट वे इज ऐप रे आपण क्वेश्चन टा देले ता तळे तापरे आसी जबो आंसर टा सेटा क्लिक करिके देखि देबे. ओके, किंबा ऐप रे पीडीएफ टा भी अछि, पीडीएफ टा को देख परिए, बट दैट इज मोर टायरसम. डायरेक्ट लाइव टेस्ट रो आपण एक्सप्लेनेशन टा देखिबे, आपण को एटा सुविधा होबो. काहे ना सेम क्वेश्चन नो एक्सप्लेनेशन रो आउ किछि क्वेश्चंस भी आपण पाइ जे परिबे एग्जाम रे. ओके, सो कीप दैट इन माइंड. सो विल स्टॉप हियर. ओके, नेक्स्ट सेशन रे हमें 26 रु 50 टा कवर करिबा. दिस इज आवर टेस्ट 1 व्हिच वाज ओके ऑन कॉन्स्टिट्यूशन, राइट. हमर 20 टा टेस्ट अछि, 10 टा टेस्ट अछि एमति सब्जेक्ट वाइज. आउ लास्ट 10 टा टेस्ट सेटा फुल सिलेबस जेमति आपनकर ओके ओजेएस प्रीलिम्स रे आसुछि. ओके, so we'll stop here then.
Sir, excuse me, sir.
कुहंतु.
Sir, टेस्ट सीरीज जाई कि जो कोटा मु किछ बुझी पारुनी सेति आपन को कॉल भी करथिली.
आपनकर टेस्ट सीरीज रे कि आपन फ्रेंड्स को गाव पचर दिन जो मन टेस्ट दोचंती ते आपन जिबे जोटी आपन वीडियोस लिखाई कि वीडियोस गोटे फोल्डर अछि जोथरे जाई कि आपन सब वीडियोस देखचंती. हां, ठीक सेमिति गोटे देखनु फोल्डर थिबो प्रीलिम्स टेस्ट सीरीज, मेंस टेस्ट सीरीज. से प्रीलिम्स टेस्ट सीरीज फोल्डर को जिबे सेठी लिखाई दिबो गोटे लिखाई थी लाइव टेस्ट अपन जदि डायरेक्टली टेस्ट दवा पे चाहउचंती ओके तापर आउ गोटे लिखाई थी डिस्कशन वीडियोस ए जो जेमती ए वीडियोटा सेठी जाई रहइबो आउ गोटे थिबो पीडीएफ ऑफ क्वेश्चन एंड आंसर्स जो लाइव टेस्ट अपन देले सब बेले बहुत जन को एमती लागे से लाइव टेस्ट को रिवाइज करिवार मु तो कहबी से लाइव टेस्ट रे जाई रिवाइज करवाटा बेस्ट किंतु तथापि जाको पीडीएफ दरकार सेठी आपनकर आउ गोटे फोल्डर थिबो पीडीएफ क्वेश्चंस एंड आंसर्स सेठी गले आपनको पूरा 100टा क्वेश्चन रो पीडीएफ आउ तार सॉल्यूशन मिल जिवो बुझ परले आपण कंटेंट को गला परे कंटेंट अंडर रे खोजिबे प्रीलिम्स टेस्ट सीरीज फोल्डर टा से फोल्डर को जिबे जदि आपनको टेस्ट टा दबार अछि लाइव ताले लाइव टेस्ट आपण देखिबे गोटे फोल्डर थिबो जदि आपनको खाली जस्ट करी रिवाइज करिवार अछि पीडीएफ रु ताले पीडीएफ क्वेश्चन एंड आंसर जो फोल्डर टा अछि ता भीतर को जिबे जदि आपनको वीडियो डिस्कशन एमती जेमती से वीडियो डिस्कशन देखिबार अछि आउतरे ताले आपण गोटे थिबो डिस्कशन वीडियोस से फोल्डर को जिबे बुझ परले
हां सर थैंक यू
ट्राई करंतु न हेले मते स्क्रीनशॉट टा पठे देबे
हां सर हां
okay fine so next year I 26 to 50 ta that we will discuss